Hey guys, Toby Mathis here from Anderson Law Group and Business Advisors. And hey, I'm going to go over a couple things today about the best entity to use for your real estate. And the easiest way to do this is by explaining what your options are.
Subscribe to the YouTube channel, click the bell notification icon so you know when a new video is uploaded. Tax laws are changing all the time. The laws are changing all the time. That's why you're first to know, you're first to grow.
First off, credentials. I'm an attorney, been doing this for over 20 years, have well over 100 properties that I own or control. And if you are dealing with any professional that does not do what you're doing, you should really give pause and think whether you want to work with that individual, simply because there's so many nuances involved with a specific activity. If you're in real estate, you better be dealing with somebody who actually owns real estate and understands the nuances. Otherwise, they're going to read out of a book or they're going to read out of a case. And they're going to try to tell you to do something that may not be practical at that time, because it is fluid. It moves around. So for example, 20 years ago, you could close a commercial property in your individual name. You can't do that anymore after the big fiasco in 2008. They don't want to be exposed to your personal stuff. And so almost always, if you're dealing with commercial property, you're going to be closing an LLC. This is absolutely the case as if you have financing. They will not even do financing anymore for the individual. You'll be a guarantor, but they'll almost always make it be an entity. So this is really important, because little distinctions like that can have a major impact on your planning. For example, let's go into the single family realm where you're dealing with rental properties. It's the opposite there. They're not going to allow you. You cannot go into US Bank or Wells Fargo and get a loan and say, hey, well, let's put it in the LLC. It's just not going to happen. That's a commercial loan. And they tend to be wiggy if it's residential property. So if I'm doing a single family residence, a duplex or a fourplex, more than likely, I am going to have to close in my name and then transfer it into an entity. Well, it becomes a very different story of like, hey, in a perfect world, I could just close an LLC, for example. That may not be possible. I may need to use an intermediary entity to mitigate the risks of having that note called due. And first off, we're going to make sure that that note is still paid. We're not going to prejudice a lender, but we also don't want to cause ourselves unneeded trouble by triggering a due on sale or something like that by tossing it in directly into an LLC. There's also tax implications. So for example, where I'm at in Las Vegas, in Clark County, I can put a property in an LLC, no tax. If I take it out of an LLC, tax. The way around that is using the first entity I'm going to cover, and that's using a land trust. So you get used to using these and you get used to working with them simply because it's something you have to use. Like, hey, if I don't want to pay an exorbitant amount of tax, I might have to use one of these entities. Or if I don't want to trigger a due on sale, I may have to use this type of entity. So the land trust is number one. And a lot of people misuse them. They don't understand exactly what they are. And what a land trust is good for is privacy, because your name is not on the deed. You can actually get these to where your name is nowhere on the deed. So they're great for privacy and holding title. What a land trust really does is it separates out legal ownership from the beneficial ownership. This is really important. So when you go to where land trust came from, it was Illinois, it was the Sears Tower. They're acquiring properties. If some of you guys know the case that I'm talking about, but the court basically said, hey, a land trust is when legal title is separated from beneficial interest. Legal title does not mean you're liable for the things that occur on the property, but the ability to rent it, the ability to control it, the ability to do things with the property is actually separated from the legal owner. Another situation where this was used is down in Disney World. Is they were able to acquire properties without anybody knowing what was the group that was acquiring it. It was actually really important so that they didn't jack up the price or for people to try to block the acquisition of those properties so they could build Disney World. Those are some just examples. In our world, we tend to use it because, hey, if I have, let's say I have, a bunch of properties, we'll just say 1, 2, 3, 1, 2, 3. I may have loans on each one of those. And I may not want to have to, hey, if I put it in each one into an LLC, I may not want to have to go through the rigmarole of contacting the lender and trying to get it justified. I may just go ahead and use a land trust where I'm just isolating each one of these things out, and then I can assign them to an LLC. Now, best practice is always going to be to separate each property into an LLC. But what if I have a portfolio loan or something like that? I may be required to have one loan on all three properties, in which case I may have a singular LLC that becomes the beneficial interest holder. Now, some of you guys are losing your mind. This is not best practice. Best practice is to have an LLC for each one. But you could do this depending on whether you're dealing with a hard money lender or what type of lender you're dealing with. So I'm just going to make this a little bit simpler. And I just mentioned the second type of entity we're going to be talking about. If I am holding properties, what it comes down to is there's really only one entity you need to know. And that is for asset protection. I'll just clarify. And for tax benefits. If I am buying and holding, I am using an LLC, which stands for Limited Liability Company. If you ever say Limited Liability Corporation in my presence, I'm probably going to make fun of you. An LLC exists for state law, and it puts a box around the entity or the activities of that particular entity. So, for example, a piece of real estate, it puts a box around it. So if something happens on that real estate, it doesn't contaminate everything else. The easiest way to think of this is if you had luggage and you have perfume, or cologne, depending on what you're into, and you have your shaving cream and you have your toothpaste. Well, all three of those things, I go on a plane, could all three of those things explode? Yeah, so I'm going to probably put those in a toiletry bag, or I'm going to put them in a Ziploc or something so that it doesn't get all over my clothes if something bad happens. Well, if they're all in one bag, then if the shaving cream explodes, for example, it's getting all over your toothpaste and your cologne. All we're doing is we're putting them in separate baggies. So let's just say I had a baggie for my cologne, I had a baggie for my toothpaste, and I had a baggie for my shaving cream. All I'm doing is making sure that if one of those explodes, it's not getting all over everything else. That's inside liability. So that's what we use for real estate. A land trust does not protect you for asset protection. It's a title vehicle only, where you're separating out legal ownership, what's on the title, from the beneficial ownership. And then what I'm going to do is I'm going to assign the beneficial interest to an LLC. So in our example, I may have LLC 1, 2, and 3. And I could just take my beneficial interest and I could just assign it to my LLC. Nobody sees that. So if that LLC, for example, has my name on it, like there's no anonymity, I can make sure nobody knows that it's connected to that piece of real estate. So for example, if something happens on this house, all they see is the name of the land trust. And that land trust, a lot of you guys don't realize this, you can use either a nominee trustee or you can use an entity as a trustee. I know some of you lawyers out there, your eyes are rolling back. Hey, you can't use an entity. Yeah, the rights to enforce is actually the beneficiary, which you're controlling. We have no problem using an entity, and I haven't seen any issues with it in years and years and years. What you do is either use a nominee or you use an entity. Whatever the case, I can keep my name off of it in a public record. So if something happens on that piece of property, they don't see Toby Mathis all over it. But if, let's just say in a weird world that it did, they also wouldn't see that the LLC is connected. They're not going to see these other properties. And what we're really getting at is that if something happens here, the world that they can see is that only that particular entity. It's that land trust. If they sue, they're only seeing that LLC. They don't see everything else we have. And realistically, the best defense is not to let them see everything that you own. If they see everything you own and you have a bunch of properties, guess what? You're probably going to get sued way more often than you like. If they can't see what you own and they don't know whether you own 2 properties or 200, then you're not inviting that. And we've seen that work over and over again, because people always say, well, have you seen that? Yes, I actually saw it. We actually had a father-son team where son did exactly what I'm showing you. Father did not. They had a liability occurrence in one of their businesses, and they settled out with son for almost nothing, like that, immediately. And then with the dad, they kept pursuing the dad because they could see everything he owns. I've also seen this work in rentals where somebody had a single rental property in their personal name, and all they did is they Googled the individual, saw where they lived, and said, hey, you must have a lot of money. You live in California. And the property was out of state. And they were like, hey, we know that you have something to lose. So they weren't just looking for insurance anymore, but they were actually pushing on the guy simply because they thought because he lived in California in a nice area that he had a bunch of money. And the guy was like literally saying, this is ridiculous. Are lawyers allowed to do that? And the answer is yes. So how do you protect against that? You don't let people see what you have. This structure right here, if all I did was use a land trust plus an LLC on my rental real estate, will keep you out of 99% of the problems. This is the structure that you use. Now, you could bypass the land trust. The land trust is our friend if there is debt on the property. If there is no debt, you're buying cash, you can go straight to an LLC. I just have found in my personal experience that it's much easier if I'm making a lot of bids on properties. For example, I'm in Las Vegas. In 2007, 8, 9, 10, 11, 12, when the economy was doing all sorts of weird things, we lost 75% of our values in the valley. And so I was bidding on properties constantly. People would go down to the auctions and you buy them cash, or you're bidding, you're doing on short sales. And there was days where we put in 20 bids on properties. I kid you not. You're sitting there and you had to have a methodology. I did not want to put the bids in my name because some of them I may not even keep. Some of them are possibly wholesale off and give them to my friends. But for the most part, we were just like trying to acquire properties. In that particular state, people would get their houses trashed and you could buy them and fix them up and sell them again. You can make a little bit of money doing that. We were doing that quite a bit, as were our clients. But you didn't want to be trying to set up an LLC every time you wanted to put in a bid, and you didn't want to have 20 properties in the same LLC. So the easy way to do this was just to put the bids in the name of a land trust. I would just have a succession of trusts, and I would always put in a bid, and then if I got it accepted, that's when I would actually create the trust. But but for me, it was really easy. I had a methodology that I would use. I'd use ABC LLC trustee of whatever the trust name I was going to use. And a lot of times we use the property address. Some of you guys are going to say, I don't want to use the property address. Fine. But that's what we used at the time. Was I'd always use the property name plus trust. So if it was on, 123 Main Street, I just called the Main Street Trust. And that was it. It was really easy to put in offers. So I didn't have to think about it. It was automatic. And then if it was accepted, it was really easy for me to create that document after that point when we were actually going to closing. So it's up to you as to what works for you. I'm just going to tell you what I've seen work for myself and my clients. And quite often it's using that land trust and the LLC. And that's about as complicated as you have to get for owning the property itself. Now, if I isolate this property and I keep the liability inside an LLC, there's still me sitting out here. Here I am, and I'm driving around. I'm doing activities where I could get sued. Well, there's something called outside liability where they can actually take my LLC away. So let's say I get into a massive car accident that I cause, and they sue the heck out of me. And they don't care about what I own. They just want to take and scorch earth and put me into bankruptcy, right? They just want to see what they can get. I need to make sure that they can't just take my LLCs. And in most states, they can. And so depending on your situation, I'm just going to tell you, there's a really easy fix to this, which is instead of me owning my LLCs directly, I will more than likely have a Wyoming LLC, pretend that says Wyoming. I'll more than likely have a Wyoming LLC own my LLC, and then I'll own the Wyoming LLC. And the reason that you do this is because Wyoming has protections that do not allow people just to take the LLC. They can get a lien against it, and that's it. Most lawyers aren't litigating to get a lien. They're litigating to get paid. And so the fact that they can't force themselves or force money means that they're not going to be nearly as aggressive, and you're going to be in a much better situation to settle anything that's occurring. Now, that's for outside liability. So all of a sudden, we just took away this, and now the outside liability is going towards the Wyoming. Now, taxes. All of this could be set up to be transparent for taxes, meaning that it'll all end up on your 1040 Schedule E, just like you owned it individually. And there's two ways that occurs. We either set it up as a disregarded entity, where the IRS is literally ignoring all those LLCs and the land trust. And I am giving you the honest truth. You could have 100 properties in 100 different land trusts with 100 different LLCs with zero extra tax returns. It all goes onto your return if that's what you want to do. Now, again, this is why you use people that actually do real estate. If I have commercial property and I'm going to sell a property, the buyer is going to need to see a tax return. And I don't want them looking at my tax return. So I'm more than likely going to make that entity a partnership. And I'm either going to make it a partnership by, maybe it's me and my spouse. Maybe it's I use a partnership by having my corporation as a part owner, or as something else as a part owner, or my LLC as a part owner, or as me as a part owner with my LLC. Like, I may be able to make that into a partnership fairly simply, so that I actually have a 1065 that I can give them on that piece of property. And that's going to be the difference between whether they can get financing or not. So now I told you I'd go over three main entities. So we did a land trust. We did, and we'll just call that one. I did the LLC too. And then the last one is our friend, the corporation. And by the way, corporation is nothing more than a tax designation. So I could be a corporation, or I could be an LLC taxed as a corporation. So when I talk about a corporation, for those of you guys who are pretty savvy, just know that I'm talking about it can be an LLC taxed as a corporation. But that's the other category. And I'm going to use this when I have active real estate. And when I say active, that means things like wholesale, flips. I might be doing it if I'm a real estate agent. That's going into a corporation. You do not put your buy and holds ever in a corporation. Like, there may be one or two exceptions to that rule, but I'm just going to make it real easy. Your default is your buy and holds always end up going into an LLC. If you have debt, you use a land trust. If I have a lot of properties and maybe I'm doing a portfolio loan, then I'm probably doing land trust with the LLC, because I don't want one LLC being on 20 pieces of property. I've done those loans. They want to have a special purpose entity that is owning the property, and you do not want to have all those properties in one name, even if you do have financing, because the most they're going to get is the equity. I get that. But your lender is almost always going to say, hey, I want to have this entity. And they're also, by the way, going to be pointing at this guy too. They're going to want a holding entity. Although if you're dealing with a major, like a hard money lender or a portfolio lender, things like that, they're almost always going to want to see a Delaware entity under that circumstance. And I'll explain that someday. But from a 10,000 foot view, what we care about is that there's three entities. And here's what they are. Again, a land trust is for holding title only, has no asset protection. You always marry a land trust with an LLC. An LLC is what you use for your holds. Make it simple. Your LLC will not destroy your 1031 exchange, your installment sales, my ability to do depreciation, has zero impact on it. It will all flow down to you if it's an LLC that is set up as a partnership or is disregarded. Now, if I set up an LLC and tax it as a corp, I'm only doing that if it's active. So if I'm flipping properties, then I'll flip through that, but just because there's an adverse impact if I do it and it flows onto my return. And I'll make it real simple for you. If you are buying and holding, so if I buy a property to hold it, it does not matter my holding period. It really doesn't, guys. That's not the test. The test with the IRS is, why did you buy this? If I bought this to hold it, it's going to go on to my 1040 Schedule E. If I file this as a partnership, it's going on a 1040 Schedule E page 2, and it's going on via K1 from the partnership, a 1065 return. Now, if I am buying a piece of property to sell it, the holding period does not matter, guys. There's actually cases out there where people held it for more than 10 years and they were still deemed to be an active business. That's called a dealer. If you are a dealer, a developer, then it is active income. And the reason this is important is you lose the ability to defer your taxes with installment sales. You lose your long-term capital gains, and all of it is active and subject to self-employment tax. So we combat that by using the corporation. We can reduce the tax hit by using an S Corp in that situation, or sometimes a C Corp. But in either case, we want to make sure it doesn't just go right onto your return, because if it does, it's going on a Schedule E, which is a sole proprietorship, and you lose all the benefits of holding property. I want to make sure that my buy and holds are separate from my active flip. So if I'm a flipper and I'm an investor, never do that in one entity. Don't do that in your name. You always separate those out. And I'll just give you a rule of thumb. The best way to structure it is to have LLCs for the holds and an S Corp for your flips, or possibly a C Corp. And you talk to a professional who actually understands these things to give you the end all be all. Now you can change your C Corp to an S Corp and vice versa. So if you mess it up, you can always go back and fix it. In fact, you can actually make an S Corp election even a year after. Like you can, if you screw it up, there's ways to fix it. Just leave it at that. But you want to make sure you're talking to somebody. Don't go out and try to do this online. Don't go out and think that there's a cookie cutter approach to it. There is not. You want to make sure somebody understands what it is that you're doing, what you're trying to accomplish, what your purpose is, and then they want to marry it to one of these guys. Now, are there other entities out there? Are there IRAs, 401ks? Are there limited partnerships? Are there limited liability, limited partnerships? Yes, there's all these other things out there. And in facts and circumstances will dictate whether they're important. But no matter what it is, it could even be a nonprofit. You're still putting it in an LLC if you're buying real estate and holding it. Even if you're in your IRA, you're still putting it in an LLC because you want to make sure that you don't expose yourself and all your other assets to liability. You're still doing this. And if there's any debt on the property, you're almost always going to be using a land trust. And you may, depending on what you're doing, you may always be marrying these two together. At our firm, we tend to be really bullish on making sure that your name doesn't appear in a public record. I can't do that necessarily with an LLC by itself. I'm going to really be using the land trust. So if I'm buying lots of pieces of real estate and I'm starting to accumulate a substantial amount of assets, the easiest way to make sure that you never get sued is if nobody can see what you own. And that's how you use this little guy. But a land trust by itself will not accomplish it. You always marry these two together. So whenever you see a land trust, you're probably going to see an LLC on the back of it if you're working with a good practitioner. If you're just doing the LLC, then more likely than not, we're going to see a holding LLC along with it. If you're doing a corporation, then quite often we're going to see entities underneath that corporation, LLCs underneath the corporation even. And remember, the corporation is just a tax designation, and it can own other LLCs. So anything that we're doing, we could still isolate out their liability. So if you're an active flipper, then there's a good chance that the flipping corporation is just the tax return that's going on, and you may see little sub LLCs underneath it holding the properties because you're actually generating a bunch of income, and we don't want to get sued, and we want to minimize our liability if there's ever a situation like somebody falls off the roof. You don't want to have your other 10 flips that are in progress to get affected. You want to make sure that you're isolating. Or if you're doing one or two, you have two projects going on. You don't want project one to interfere with project two, or vice versa. And you want to isolate those out. So if anything goes wrong, you're minimizing your risk. So I hope this helps give you a little overview. So again, I'm just going to reiterate this. Your rule of thumb is if I have single family residences, duplexes, or fourplexes, and I have debt on them, I'm almost always using a land trust. If I don't have any debt, then I may be putting it in an LLC. If I have multiple pieces of property, I'm not going to own my LLCs directly. I'm going to have a holding entity like this little guy, more than likely holding my interest to protect the properties from me and me from the properties. And then if I am a flipper, or if I am a real estate agent, or if I am a developer or a dealer or a wholesaler, and I'm actively making the money in the real estate, I'm almost always going to be an LLC taxed as a corporation or just a flat out corporation. Your state and the rules in which you are operating under will dictate what we're using. And I hope that helps you make better decisions in your real estate investing.